Our next case is Stuth versus Homeowners Insurance. This is a 15-minute mini oral argument on the application.
Okay. Try to remember.
Good morning. You both have 2 minutes of a free fire zone, and you may reserve time for rebuttal, but we ask that you keep track of that time.
Thank you.
You begin when you're ready.
May it please the court, Steve Hicks on behalf of the appellant John Stuth. I'd like to reserve 2 minutes for rebuttal. If I can, I will try to keep track of my time as best I can. The court has asked a question in the order granting oral argument on the application, whether the plaintiff's injuries arose out of the operation or use of a motor vehicle under MCL 500-3105 sub 1, and including as a subpart of that question, sort of a rephrasing of it, whether there was a sufficient causal connection between the van that the plaintiff encountered and his injuries to entitle him to benefits. First of all, I would say that I think the parties are in agreement that the court has asked the right question here, and I say that only because there was some confusion in the trial court about cases that are cited under other provisions of the No Fault Act. I think we all agree that this is an entitlement question under MCL 500-3105-1, as the court stated. It's not a priority question under 3114.5. It's not a disqualification question under 500-3113B, where the involved in the accident language is used. Although that involved in the accident has always seemed like a convenient shorthand for arising out of, it is not precisely the same test. So I'm focusing on the arising out of test, because that has always been the test for entitlement to PIP benefits. That's true whether the person seeking those benefits is a motorist, a motorcyclist, a bicyclist, a pedestrian. That is always the test that we use to determine whether there's an entitlement to PIP benefits. Where this case gets interesting is that the Court of Appeals brought in the concept of fault in reversing the trial court's determination in this case that Mr. Stuth was entitled to PIP benefits. And that's the fundamental problem that we have in this case. When you look at the No Fault Act, I mean, there's a lot in the No Fault Act that's difficult to understand. There's a lot of ambiguity. There are a lot of cases that are going to be heard by this court. But there's one thing that the No Fault Act is absolutely clear on, and that's that it is a no-fault act, that fault is not a consideration here. There couldn't be any clearer expression of intent from the legislature than that. And when I say that, I'm saying MCL 500-3105 sub 2 says PIP benefits are due without regard to fault. Without regard to whose fault? Well, the person claiming the benefits. That's the person we're focused on. That's the person whose fault that matters, and it shall not be considered in determining PIP benefits.
Is that inconsistent with what the court said in DMC? Do we need to overrule DMC for you to succeed?
I think you do, because my argument is that in DMC versus Progressive, the Court of Appeals adopted a test on top of the test that we already had. We had a test. It's arising out of. We use it in every case. We have a meaning for arising out of. We know that means more than incidental, fortuitous, or but for. But in DMC versus Progressive, the Court of Appeals, in a published opinion, layered another test upon that. And that test was whether there was an actual objective need for the motorcyclist to take evasive action. I feel that we've strayed into
Don't
similar...
we need some sort of a test when there's no collision between the vehicles? There have to be some way to determine whether another vehicle operating on the road doing something had something to do with the accident, right?
And there is one. And that test is arising out of the use of a motor vehicle as a motor vehicle. And what does that mean? It's not like that is a new test. I mean, it's existed in the context of liability coverage. Is it going to be provided in a particular case? It's used in UM, benefits cases. In fact, we adopted it into the no-fault stand. We adopted the definition of more than incidental, fortuitous, or but for from the liability coverage context, because that had a meaning that we could understand. And we could say that arising out of means something less than proximate cause. But what does it mean? More than incidental, fortuitous, or but for is the test for arising out of.
Before we get into this sort of word salad, because I don't think any of those words really help and then it's less than proximate cause, and it's more than but for, and, oh, that's perfectly clear to nobody, and certainly to nobody, a layperson who serves on a jury. So I tend to think about these cases, I hate to sound like my colleague Justice Bernstein, but to try to simplify and think about the facts that courts are gonna face, not just in this case, but in all the future cases. So we have to, these are, I guess we can categorize these as evasive action cases. And so we have to think about when there's coverage when somebody takes evasive action, right?
Well-
So you have to make some judgments about, I think, whether the person had to take evasive action or didn't have to. Would you agree with that?
I disagree with that completely.
So it doesn't
Because-
matter, if the other car is driving perfectly well down the road, not doing anything wrong, no traffic violations, and the
That
person
does
takes their
matter.
motorcycle and drives it into the ditch and says, I thought that guy,
No.
I could see the look on his face, and I just thought he might just come over, and so
No, that's absolutely not what
Why
I'm
not?
saying. Let me make this distinction.
how do we make where do
See,
we draw the line?
When I talk about these cases, I talk about them as no physical contact motorcycle crash cases.
Agreed.
And that's probably the best way to categorize them. But when we look at them, we have to focus on something to figure out, in terms of what test you want to figure out more than incidental, fortuitous, or but for. What do we focus on? First
So
of
that's
all,
what the Court of Appeals and DMC tried to do, right? Come
Well,
up with a,
but their focus
with
is
a
wrong.
line drawing sort of thing that people could understand, and then courts could apply, and
that
litigants
is
could
absolutely
understand.
what they tried to do.
And so when we throw that out, you're gonna replace it with something even better and more clear, right?
I'm gonna replace it with something that's consistent with the No Fault Act, because DMC isn't. If you focus on the motorcyclist and their actual objective need to take evasive action, you have brought fault into the no-fault system. And that is absolutely not
The court
permissible.
addressed that. It thought you're addressing it just for this determination of causation, but not in terms of entitlement to benefits.
Respectfully,
Whose
there's
fault
no,
it was, if it was the other vehicles or your fault.
respectfully, there's nothing in the No-Fault Act that says fault cannot be considered except for causation, then you can go there. It says without regard to fault.
All right,
So the focus on the
I see
motorcyclist-
that in 510 or 31052, but what's your test? State it clearly and succinctly so that all the future courts can apply it and litigants will understand it.
Sure. Well, the test, first of all, you have
Don't
to.
just say fortuitous and but for and
No.
more than
I'm not going to
incidental.
say that because we all
Okay.
know it and we know that it's the test. But in a no physical contact motorcycle crash case, the focus has to be on the motorist because the motorist is the one operating the motor vehicle. And the test is arising out of the use of a motor vehicle as a motor vehicle. Forget about the motorcyclist for a second because you're going to stray into fault. I know it's counterintuitive to do that because it's an accident case, but in no fault, we assess whether someone's entitled to PIP benefits based without regard to fault. So when you look at the
I'm driving my RV
motorist,
down the highway, and what do I do to be liable, for there to be liability? What-
well, certainly crossing into the double yellow,
So is it
which
a
is the
civil
example in
infraction?
this case.
If you do a
is-
civil infraction, commit a civil infraction?
I don't think you have to commit a civil infraction. I think, if you're swerving around in your
Arguably, what
lane,
happened in this case is not a civil infraction, is it? If you go over the line
I believe it
briefly?
is. I believe it's a violation of 257.642(1), which says you'll drive in your lane as nearly as practical, entirely within your
I
lane.
think you're allowed to go over the line a couple times, a little bit.
We do it, but if people react to that, it's still, our operation of the motor vehicle precipitated that reaction.
But let me get back to the
And that's
general
the
level.
fundamental point.
Does it have to be a civil infraction, or doesn't matter?
I don't think it has to be a civil infraction.
Okay, you have to do something that, would cause a reasonable person to take evasive action? Is that your test?
Well, no, see, your focus again is on the motorcyclist. What you have to look at is what the motorist did and whether it was their operation of the vehicle that
So DMC, motorcyclist was going 100 miles per hour.
okay?
Okay, so that's like a fault thing, but the vehicle arguably didn't do anything there.
Mere
So-
presence on the road.
So we get rid of DMC, but how do you apply DMC under the statute? What would happen in DMC
You
if
mean
we get rid of the
DMC
holding?
goes, well,
How do you think it should have
I
been
think I made
handled?
this clear in the brief that DMC really is a case of mere presence on the roadway. If there's nothing going on with the motor vehicle at all, if it's driving within its lane its headlights are functioning so it doesn't surprise you in some way, it doesn't blind you with the headlights. If there's really nothing going on with that vehicle, its mere presence on the roadway is not enough.
What if,
But-
what if the vehicle has its hazards on for whatever reason?
I'm sorry?
Has their hazards on?
Has their hazards on? If the motorcyclist were to say, yeah, you know, it blinded me, I couldn't see what was happening, and so I moved to the right side of the lane, I lost control, that could be enough, but I think it's really a fact question in that case. First of all, you know, is the fact question, are we believing what the motorcyclist is saying, especially in a situation where the other vehicle doesn't stick around? Here we don't have that issue at all because the trial court made factual findings.
How do we
They were entitled to do
evaluate
it.
something happened, whether it's enough of a something, without thinking about how a person would respond to that? So what, if it's not something happened and it's a violation of the traffic code,
Well,
what standard am I using? It's just
Well, the
something
fact
that
is-
somebody thinks is a big deal or not a big deal?
yeah, you want to apply, you clearly want to apply a test.
I know,
and-
I'm trying to.
No,
I'm very
you-
sympathetic, if you heard the prior
Your
argument.
question
I'm
presupposes.
sympathetic to the trial judges that we're gonna impose this new test on.
Yeah,
So that it makes some sense.
Well, it's an easy resolution for trial judges, because it's, quite often, it's gonna be a fact question for the jury.
So everything goes to a
on
jury.
rising. No,
That's a
I
popular answer these days.
But
think
Every
that's-
case goes
aren't
to a
you
jury.
saying
I think
even-
that's absolutely, if I can
in-
just answer
okay, sure.
Justice Vivian, I'm sorry. Absolutely, everything does not go to a jury. I just said that mere
We just said it's
presence,
gonna be very commonly a fact
mere
question.
presence on the road is never gonna get you there.
I don't even know what the fact question is either, by the way. What does the jury, do we just have them rule based on sympathy, or are we gonna give them some kind of a standard? Or do we just tell them, keep repeating fortuitous but for, and don't you know what that means, kind of a thing?
Well,
I don't think you're advocating for a rule of sympathy as the rule, right? I think,
Certainly
but
not.
even under your formulation of saying arising out of the use of a motor vehicle as a motor vehicle
yes.
does not include mere presence on the road, right? Under DMC, it was mere presence
I
on the
think-
road. That vehicle was being used as a motor vehicle. It was being driven. It wasn't the situs of the, it wasn't like a block on the side of the road that the person.
It was mere presence on the road.
It was mere presence, so is it your position that under DMC, that wouldn't have met the test of arising out of the use of a vehicle as a motor vehicle? Mere
Yeah,
presence
it would-
doesn't do that?
Absolutely, it would not do
So-
that, and
so
it didn't
how-
in DMC.
I think the thing we're struggling with is, we know mere presence doesn't make it,
Okay,
and fault of the motorcyclists in whether or not they needed to, or how they should have avoided it, or was their evasive action necessary or reasonable? What is the, where,
I
what
think
is
this
the
was
test?
probably best articulated in the CPAN amicus briefing, when they said there has to be some identifiable act. I approached it somewhat differently, and then the act has to meet the causation standard, which is typically.
Mere presence plus something more.
Yeah, and that can come in many ways. I mean, if someone is clearly distracted and driving, and you're watching them coming at you, and they're not looking up, they're looking at the ground, they're weaving a bit in the roadway, if I'm a motorcyclist, I'm gonna take some precaution
Poses a
against that.
danger, but not to a reasonable person. To what person? To the person, to you, to me, to, if I can't say it poses a danger to a reasonable person, what kind of standard can be applied in court is that?
Well, when you.
Because I
when
can
you-
agree with you, if it poses a danger to a reasonable person, that now we're approaching some standard that courts could
and-
apply. So who gets to decide whether the
You are
person
firmly
looked?
you are firmly in the realm of fault again.
Who gets to decide if the person was distracted enough? I just want to know who the decision maker is, or is it just a purely subjective? So if the person says, well, I thought I saw the guy look the other way, that's enough?
I think there
It
has
either has
to.
to be subjective or objective. I don't understand the third way that you're trying to get us to go
No,
down.
I
It makes
think,
my head kind of like explode.
I think where you're losing it is
I
the.
must be losing it.
Where you're losing the focus is that you're having a fundamental problem focusing on the motor vehicle.
I'm
and what-
focusing on the motor vehicle.
And what they were doing.
They did something. Now, how
But
do
then
we
you're
evaluate
asking-
what they did? How
Then
do I
you're asking,
evaluate it?
but then you're asking a corollary question which is it appropriate what the
They
motorcyclist
did something that
And that's
caused
where you
somebody else
vary.
to do something, right? We have a couple things going on. They did something that caused somebody else to take evasive action.
That's absolutely true. We know they crashed. I mean, all of these cases are about
So
crashes.
just the
That's
fact that
what's
somebody
happened.
took evasive action, is
But
that
the
enough?
question
Is that enough?
is about entitlement to benefits. And the question is merely whether there was a motor vehicle, whether the motor vehicle.
Okay, let's go at it from the other direction.
Pardon me?
Let's go at it from the, I'm gonna get my microphone here, the other
I'm
direction.
fine with that.
I don't think your position is that everybody who crashes their motorcycle is entitled to benefits.
Correct.
So when is it that when I take evasive action and I crash into a ditch that I'm not entitled to benefits? Let's talk about those situations.
Exactly. DMC is the perfect example of this.
So where the car doesn't violate any laws and the driver
All
looks
that car did
alert?
was drive down a road at night.
So if
There
the
was
car
no
does
evidence
anything
the car
else,
did anything.
if the car does anything else other than drive perfectly down the road, then I'm entitled to benefits?
No, I don't think that's necessarily true, but I think it could create a fact question if there's something that the motor vehicle did that the motorcyclist says, yeah, that, I was reacting to this
So
thing that they were doing.
If they allege anything other than perfect operation of the motor vehicle, it goes to a jury. That's the standard?
If they make an allegation of the motor vehicle doing something more, and it creates a fact question
Or
on that-
something less, anything other than perfect operation of the vehicle?
Well, no, it has to be something that would contribute in some way to taking evasive action. I mean,
How would we
if the-
evaluate that if we don't consider whether the other person was being reasonable?
If the motor vehicles, if the civil infraction of the motor vehicle is they had, extra lights on their car or something, they had this or that, but the motorcyclist doesn't say, well, it wasn't really about the lights, I just saw a truck coming. I mean, that's it. It's not going to be enough.
Let's go back to the motor vehicle has its hazards on. For whatever reason, the drivers hear something, I'm gonna put my hazards on, I just wanna make sure that everything's okay with my car. They're driving the speed limit, nothing is wrong. And
I'm sorry, they put the hazards on?
yeah.
Okay.
They have their hazards on.
Yeah.
You're allowed to do that when you're driving if there's an issue. They're not slowing down anything, but the motorcyclist, comes around, they see a car with their hazards on and think, oh, there's something wrong, and then they slam on their brakes or maneuver because
They get PIP benefits. Because the hazard light, putting the hazard lights on, this is a good example, putting the hazard lights on tells the oncoming motorcyclist, in this case, something's going on with this vehicle. I don't know exactly what it is, but I should probably be careful. And so in being careful, the motorcyclist decides to come off the roadway, maybe wrongfully or rightfully, they can be at fault. They go onto the shoulder, they lose control, they crash, just as Mr. Stuth did. That's a perfect example.
Isn't that because, I might not even disagree with your assessment of the answer to that question, but isn't it because a reasonable person driving the motorcycle might slow down if they see another vehicle with their hazards on? Isn't
Well,
that the answer to your question?
I think you've strayed into the territory that the dissenting opinion got in the Court of Appeals. We can absolutely win under the actual objective need test. It is inconsistent with the No-Fault Act. It is fundamentally inconsistent with the No-Fault Act because it focuses on the motorcyclist's fault. But if the court likes the test, much as we used to like tests
I
that...
don't speak for the whole court. I only speak for myself, and
Sure.
I try to be persuasive, but.
Well, and
rarely
if
succeed.
if you
But-
favor that test,
But
Justice...
my point is only that,
Yeah.
to determine whether what the person did is something that is compensable, and to differentiate between a vehicle that's driving perfectly
Oh.
well down the road and one that has their hazards on, the distinction you're
Oh.
making, I think, is that a reasonable person would do something. And if that something
I'll-
causes an accident or results in an accident, then they should receive compensation because they did something in response to someone else's operation of a
I'll
motor
grant you
vehicle.
only that it's intuitive to go there. The test came out of a case with bad facts, and they created an additional test on top. We satisfy that test in
But
this
so what
case,
your
and I've
test
argued that.
is something more than simply driving, but the jury, you get to decide whether.
Well,
whether,
I don't
was
think,
enough.
in the involved in the accident context, which is different, but similar, there's been discussion of, was it active or was it passive? Was it a passive activity, or did it somehow contribute to the accident? I don't think that's a faulty analysis. I think it's very similar to what CPAN argued in their amicus briefing, which is you've got to have an identifiable act, and it has to, in some way, have a connection to the reaction to that, the crash. I think that's fine. I know it's counterintuitive to take ourselves out of the fault realm. That's always been the difficulty with no fault. But DMC is fundamentally inconsistent with the No Fault Act, And if the court disagrees with me and wants to keep DMC, then there was actual objective need in this case. If that's the assessment the court wants to do, as inconsistent as I find it with the No Fault Act, we still would satisfy that test. So I'd ask that the court reverse. I don't think I have any rebuttal time at this point, but I appreciate the questions. Unless there's further, thank you very much.
Good morning, Your Honors. May it please the court. Daniel Saylor appearing on behalf of the defendant appellee homeowners. I want to start with what counsel said about what the Court of Appeals so-called fundamental problem being that it's making fault a consideration. And this is totally untrue, totally false. I frankly don't know how that argument can be asserted. What the plaintiffs and the dissenting opinion below both insist on is that what Mr. Stuth did in reacting and swerving and then ending up easing down off the road into the field was reasonable. It was reasonable, which is another way of saying he was not unreasonable. So who's injecting fault into the equation here? Our analysis and the DMC, if you read the DMC and understand what they mean by distinguishing an actual objective need for evasive action versus subjective mistaken perception of the need for evasive action, if you understand that that is not fault finding or a fault inquiry at all, it is a purely subjective, causation inquiry. Because what the court was trying to convey is that was evasive action needed in order for there not to be a collision or not? And if evasive action was taken when there wouldn't have been a collision anyway, it's not judgmental. It's simply saying that that was a subjective mistaken perception of a need for evasive action. It's a pure causation question. And I think that take fault out of the inquiry and you just simply examine whether, but for the evasive action, would there have been a collision? And I refer to the Bromley case as the perfect example of when, even though there was no collision, no physical contact, it's still a motor vehicle accident. It's still the operation of the motor vehicle that produced the injury, and therefore it's covered.
So help me understand. I think you would agree that physical contact is not required.
No, not
Okay.
if there's equivalent conduct or
Well,
action.
I guess that's what I'm struggling with. Why is, you don't have to have physical contact between the motor vehicle and the motorcycle. But if it's a case of evasive action, then it must have been evasive action to avoid physical contact. Why is it relevant there? Or why is that a proper test? If you
Because-
don't actually have to have contact with the vehicle, but if you're trying to avoid, if you're claiming that your accident occurred because you did some evasive action, that only qualifies under the No Fault Act if you were trying to avoid physical contact.
Yes, because otherwise it's not a motor vehicle accident. The motor vehicle has to produce the injury. And in Bromley, the motor vehicle directly caused physical injury, whether it was by mechanism of a head-on collision or, as the case specifically says, forces him off the road and into the guardrail. Either way,
What if, but,
it was going to be an injury, whereas that is not the case when a motorcyclist, or it could even be a pedestrian. A pedestrian, is on the roadway, the road crosses a river, sees a car coming, and maybe the person's not mentally well or something, and they just, oh no, they're out to get me, and dives off the bridge into a ravine and gets injured. In fact, in that case, and in DMC, and in our case, in each case, the motorcyclist is reacting to an approaching motor vehicle on the basis of, I might get injured by this motor vehicle. So there is some connection to the operation of the motor vehicle, but when it's just incidental and but for, when that's not what produces injury, then it's not covered. And it wouldn't produce injury if, as the DMC case said, it was a subjective, erroneous perception of a need for. Then it's not a motor vehicle accident. And I think by and large, especially with motorcycles, because they pose a unique problem for no fault. That's why they were not included in the definition of motor vehicle in the first place. And early on, they didn't have a separate motor vehicle, motorcycle provision. Somebody could have auto insurance, and then they'd get in an accident on their motorcycle, and their own insurer would have to pay their benefits. They changed that because of the uniquely high risk of injury with a motorcycle. So motorcyclists are out there interacting with traffic with motor vehicles all the time. And in order for them to come in to the protection of the no-fault scheme, you almost need an actual collision with a motor vehicle. But you don't necessarily have to have actual contact as long as it's still the motor vehicle who forced him off the road or effectively produced the injury anyway. And that's the case in the Bromley case.
But counsel, good morning, and I totally appreciate your argument, but isn't that really kind of what happened here? The van crossed over and then was able to correct, but it still crossed over. So the implication for the motorcyclist was that if evasive action isn't going to be taken, then there's going to be a collision.
Except for that we have the plaintiff's own testimony as the one person who saw the whole thing and testified that had he done nothing, nothing would have happened. If he just stayed in his lane.
What if he had said, all of that happened, and instead of saying, I don't think, I forget what he says, that if you had continued on the same path you were traveling, there would have been no accident. Is that right? And he says, yes. What if he said, I don't know? Or, I can't really tell.
Well,
I mean, would that have been sufficient then to say, or at least at a minimum submit it to the fact finder?
it could, depending, it could. Let's change it slightly, and let's say he immediately took a sharp turn on the motorcycle and rolled the motorcycle off to the side. I mean, somebody might think that's an overreaction, but let's say that he thought that was necessary to avoid a collision, and the facts could support a reasonable finding that, yes, it would have been a collision had he not done that. Here we have proof that it would not have, but let's say that the evidence could support either way.
What do you say is proof that it would not have? His own assessment of saying, I don't think I would have hit him. Is that what you're saying is the proof that it wasn't to avoid physical contact? Because his assessment was, if you had continued on the same path you were traveling, there would have been no accident. And he says, yes. That's the proof that there would not have been physical contact?
On this record, that is the conclusive fact. That is, it turns out.
So had a plaintiff testified, I don't know?
Well, that's what I was getting at before.
Okay.
It could be a fact question for the jury, but at least the question presented to the jury, we were wondering what the fact question would be. It's purely a causation question. But for the evasive action that was taken and produced, the injury, we know the evasive action produced an injury. But for that evasive action, would he have been injured by the motor vehicle? That would be a fact question when the record creates a question of fact.
What if we go back to the point of the decision that the motorcyclist makes? And your opposing counsel was fighting me, but it seems to me this, the question of whether it was reasonable to take evasive action doesn't necessarily depend on whether ultimately there would have been a collision or not, because that's not something you could know with certainty at the earlier point at which you have to make a decision about whether to take evasive action. So if we don't overturn Detroit Medical Center, what's wrong with us reaching the conclusion that the question is whether it was reasonable for the motorcyclist to take evasive action, depending on, or based on, or in reaction to the manner in which the motor vehicle was being operated?
Because now now the whole question is a fault-based question. Was he As I say, asking
I
if he's
look
reasonable.
at DMC, it says there must be some activity by the motor vehicle that contributes to the happening of the accident beyond its mere presence. It also said, in this case, there's no evidence that the motorcyclist needed to take evasive action to avoid the motor vehicle. What if there is evidence here, in this case, that the motorcyclist reasonably believed that he or she needed to take evasive action, even if it turned out that the van made some miraculous course correction and that after the fact, I mean, those facts are irrelevant to the point at which the motorcyclist is deciding what to do, right?
Well, as Justice Kavanaugh was saying, I think that where the record supports a question on that, not on reasonableness, but on what ultimately would have occurred causation-wise, what would have happened.
So
That
had
could
you-
be a
If
question
you
for
had
the
an
jury.
accident reconstructionist that could have shown the trajectory and all that and shown that contact never would have occurred, perhaps, but what we have here, just to be clear, is him saying, yeah, I think if I had stayed on the path, I would have avoided him.
Well, he didn't say, I think. He said,
said,
yep,
yeah.
it wouldn't have happened.
He
Yep.
said, yeah.
Yep. He said, is it correct? Nothing would have happened? Yeah, that's correct. But let me
But does
distinguish.
something have to happen? I mean, his perspective in taking the evasive action was that something could happen. So is that the nature that, like, something has to happen? Because what if the general perception or the belief of that individual is, wait, this van veered over. Now, yeah, it corrected, but he didn't know it was going to correct. So do you actually have to have that sense of a collision, or is it just the fact that a natural instinctive reaction would be that I better do something because this van is coming right at me?
Well, to be clear, he saw the vehicle correct. He said he saw it correct, but he flinched at that moment. He even said, I flinched. In response to that, I flinched, and then I reacted to the flinch. Factually, I think it's important to note here. Hopefully we'll have enough time to get back to the legal standard and all this too. But I think it's clear, I want it to be clear. In Bromley, it was all one immediate accident. It was either going to be a head-on, or he forced him off and he hit the guardrail. That was an arising out of accident for a motorcyclist injury. Here, it was more stretched out than that. He flinched, he veered to the side. Probably, if we are talking about what would a typical person do, a reasonable, even though that's not part of the test, he would probably veer over to the corner of over to the right part of the lane, say, hey, what's that guy doing? And he saw him course correct, but he flinched, and he probably went over there. Apparently, he did go over to the side, touch the shoulder of the road, and then he explained, I decided to go down, ease down into there's a little downhill into the field. He decided to ease on down there real gently and just go around in the field and come back and continue on my way. While down there, he hit the sand unexpectedly and went over.
Do we know how long this all took to occur?
We don't know how long. He just
I
described
mean,
what
when you
did
think
happen.
of a van and a motorcycle approaching each other and
He sees
crossing
it
one, getting near the second, coming back, and the motorcycle, I mean, it could have been instantaneous, or it
Well,
could have
I
been
don't
a
think it was-
leisurely
It couldn't
stroll
be
down
quite
off
as
into the median.
instantaneous as all that, because he said there was time for him to make a decision to go down into the field, and he saw that it was, relatively flat field. He talked about the little downhill decline. He went down expecting, had a plan to turn around and come back up, but he hit the sand over there. It's not like the vehicle forced him into the guardrail. It took him to the side, and maybe instead of risking the gravel on the shoulder, that's when he decided to go down there. And conceptually, it becomes almost a separate event, and it becomes a motorcycle accident and not a motor vehicle accident, even though the motor vehicle, we can
When does
stipulate
it-
was a cause in fact at
When
the
does it
beginning.
transition to that? Help me understand that point. So when the motorcycle reacts
He
and
flinched.
goes off the road, and if they make a decision to go further off for whatever reason, that's...
Well, he got to the shoulder and decided to head on down into the field and just turn around and then come back up. And while down there, he hit that soft sand and came to an abrupt stop.
Isn't that all a question of fact to be decided by the fact finder of whether or not, was that reasonable action to take? Was the evasive action necessary? As
But-
opposed to saying as a matter of law that short of immediately about to hit a guardrail, you're covered, but short of that, you're not. I mean,
Well, you can't.
you
I-
might win that factually, right? I mean,
Well-
you could win and say it wasn't reasonable, or it wasn't necessary, or he would have avoided it, or he made a decision, it stopped being a motor vehicle accident, became a motorcycle accident. You might win that factually, but we're talking the legal question.
I think, may I answer the question?
Sure.
I'm out of time.
Of course.
The thing is, you can't inject, was it reasonable for him to have done this? It wouldn't have made a difference, as it turns out. On this factual record, we know there was not going to be a collision either way. He concedes that point. And maybe it was reasonable, though, understandable.
It would be an expansion, I guess, of DMC. DMC is actual need. Was there actual need? That's how this case
In order for there not to be a
was
collision.
decided. Well, I guess
But
what I
he-
don't
but
what I don't
to change
understand,
it-
what I don't understand is if somebody reasonably believed there was an actual need based on another person's, the way they're operating their RV down the highway, why isn't it fair to also say that injury arose out of the person's operation of the motor
Because
vehicle?
from a pure causation standpoint, it didn't arise out of it, because but for the evasive action, there wouldn't have been any accident.
But if I
And so-
reasonably believe I need to take evasive action, I'm wrong,
That's
but my
right.
belief is reasonable, you're saying this phrase,
I'm saying that
that's not
because
compensable under the No-Fault Act?
I think that you cannot, and this is why I think it's this, the attempt to shift we're the one injecting fault. Fault is not part of the inquiry. And to say that, yeah, but he was reasonable, is just another way of saying, was he
but DMC
unreasonable?
the
If he's
DMC
unreasonable, he's defeated. If he is reasonable, he's entitled.
The DMC
That makes
court-
fault a test.
The DMC court does not disclaim any consideration of fault, right? It says the ultimate decision of entitlement to benefits is not based on fault, but it acknowledges, I think, I can't find the language right now.
No, I know
but
he's
it
trying to-
acknowledges that there's a fault consideration in the causation analysis, does it not?
Well, fault, as we know, fault is a combination of culpable action, not something blameworthy, or I don't know what the right word would be, but something culpable plus causation. But we have to take the bad conduct part of it out and don't consider whether they were bad or good, reasonable or unreasonable, careless or careful. That has to not be part of the inquiry. Only the causation part can be part of the inquiry. And that's the distinction that the DMC case makes when they say there's a difference between actual objective need for evasive action, because otherwise there'd be a collision, versus subjective and erroneous perception of a need for evasive action, which means it was unnecessary in the sense that there wouldn't have been a collision either way. It may be the rare case when you've got a record
Once you say it's
showing.
subjective and erroneous, doesn't that start to invite a question of whether a reasonable person would have reached the same conclusion?
It's only erroneous in the sense that there would not have been a collision
Whether there was
with or
an
without the evasive action,
whether there was an objective need to take the action.
in the sense of whether otherwise there would be a collision. It's just causation. And the thing is, you have to draw the line somewhere in order to separate a motorcycle accident that happens with, surrounding motor vehicles involved, and they're, like I say, they're interacting with motor vehicles all the time. When there's no actual collision, there has to be a line drawn in order to separate a single motorcycle accident from a motor vehicle accident that injures a motorcyclist. And I think that the best place to draw that line is on that causation question, not a question of how reasonable was the driver of the motorcycle or even the other side. I don't think the fact that he touched the yellow line versus if he came an inch and stayed in his own line makes any difference whatsoever, because fault's not part of the inquiry. It's just causation, and I think, my brief lays this out, so revisit it, and you'll have the rest of my answer. Unless there are any other questions, I think my time is up.
Okay, thank you both. The
Thank
case will be
you.
submitted.